Welcome to Obsessed with Success, starring Russel Morgan.
You're listening to Obsessed with Success with Russel Morgan of Morgan Legal Group. Russell doesn't just draft contracts, he builds legal armor around businesses. My name is Kevin Rosenquist, and in today's episode, we're talking about the contract mindset, how founders, creatives, and professionals can use smart agreements to grow with confidence and avoid costly disputes. Russell, great to see you again.
Kevin, great to see you as always.
How do you think your litigation background has shaped the way you approach contracts?
Litigation is a very unique part and area of law. And I think the biggest impact has to be all of the what ifs that could go wrong that I'm thinking about now when we're going into an agreement. All the possible outcomes and all the ways that unfortunately things fall apart when contracts go south. So going into an agreement, we're looking at, in some cases, what is our worst case scenario? What is our exposure? What is our potential loss if things don't go right? And what is it going to cost us to enforce our rights if something goes south? So it becomes a bit more defensive coming from the world of litigation and understanding that things in court really do drag out for years. And unfortunately, a lot of people do it just for the sake of dragging it out. It really is, in some cases, I've seen it used as a means to get people to negotiate, to settle.
Mm-hmm.
So the tighter your contract is, and when I say tighter, I mean the clearer the language is. Add a couple of extra lines in every paragraph. Make sure you've laid out everything in simple language, but enough to make sure you're protected from all possible elements. It's worth the extra mile. And it's not so much a question of value. Of course, the more money at stake, the more we're concerned about a contract's validity and what can go wrong if it is violated. But any contract needs to be written right.
Mm-hmm.
A simple lease agreement or an agreement between people who live together needs to be written well in case things fall apart, or just to enforce, to keep the peace. We write a lot of contracts just to keep the peace. And it could be something simple so that there's no ambiguity in a relationship. It could be a prenuptial agreement between partners. It could be a postnuptial agreement between husband and wife, and separation and division of assets. In some cases, it's just so we have clear understanding amongst ourselves, between the people involved in the contract, what you can and what you cannot do. And that's the most important function, because the more preventative we are, the less likely there is going to be a dispute. You can't make it absolutely bulletproof, but we can take steps to make sure that it's as safe as possible going in.
You've talked a little bit about some of the dangers. Are there any overlooked or maybe, lesser known dangers that can happen in a contract if not done right?
I've seen some pretty terrible contracts in my life. I'll be honest with you. Known dangers, a lot of people miss basic stuff.
Yeah.
Notice requirements. Choice of law, which state governs an agreement. Let's say you have somebody who's in California doing business with someone in New York. If has to be a dispute, or if there is a dispute, where is it taking place? And, this is something that people miss more often than not, that there's no choice of venue or no choice of law clause. Which place are we doing it in? What state are we doing it in? If there's a dispute, which court are we handling it in if there's a dispute? It's one of the most common errors that we see all the time, and people get into what we call forum shopping, where one side says, I want to file it here, the other one says, I want to file it here, and they're literally debating which court is the most advantageous, which one is more favorable to the party that's going forward and suing first.
Yeah, that's definitely one I wouldn't have thought of, but it makes a lot of sense for sure. You've mentioned preventative law in past interviews. Does that pertain in the contract context? And if so, can you explain what it would mean?
Absolutely. Preventative law is planning for future issues. Contract law is one of the prime examples where we practice preventative law. The whole purpose of a contract to begin with is to outline the terms of our agreement. We have a meeting of the minds, right? There's an offer, there's an acceptance, and there's a meeting of the minds on the terms of your contract. And it's one of the foundations of your contract is we're planning for the future, not necessarily for something bad to happen or for the contract to go south, but we're laying out the terms of your agreement. This is what will happen in year one. This is what can happen if there's a deviation. If, let's say, there's a new product that you're launching, how are we pricing it? If there's a new way for us to use your trademark or your patent, a new revenue stream, how are we dividing it up between us? If we're selling to a new client, who brought that client in? Is there an incentive for us, one of the parties meaning, to receive more compensation because it's my client versus your client? These are just some examples of preventative law. It's the what ifs that happen in business agreements that we can predict today to avoid unnecessary and costly litigation. And a poorly written contract can cost you double, if not triple, in litigation expenses just to recover what you should have gotten by contract and legal fees. And sometimes this is because the other party's just not doing what they're supposed to do. Sometimes it's just because they've defrauded the other side.
Mm-hmm.
And in both examples, you still have to enforce it. You still have to go to court. You still have to hire counsel. You still have to get lawyers involved, unless you're handling it on your own, which again, we don't recommend in Morgan Legal, but not everybody is willing or able to hire counsel.
Mm-hmm.
So the best thing you can do for yourself is make sure that your contract is as preventative as possible. If we step into the other side, breaches, when people go to court and they're fighting on, whether it's valid or whether who's right and who's wrong in the agreement, that's already remediary. We're trying to fix a problem. Preventative law is making sure these problems don't happen, or if they do happen, we've already planned for them. When we get into the world of breach, you're already in the world of a remediary practice. Litigation is inherently remediary. We're coming in to fix a problem. And a lot of the times we're addressing problems that, had preventative law been practiced, had you made sure that these things were addressed in your contract, maybe we wouldn't be here, or maybe we wouldn't be here for as long, or fighting over so many problems. Maybe it could have been one issue instead of 10. So as with all of our areas of practice in Morgan Legal, measure twice, cut once. Review it an extra time, read it with your attorney, make sure it's clear, make sure it is preventative as possible before you put pen to paper. Because once it's in place, that's it. Once it's signed by both parties and it's a valid agreement, the only way for you to really change it is if the two of you are, let's say there's more than two people involved, get together and agree to modify the contract. Otherwise, you're stuck. Whatever's written in that agreement is going to bind you as long as it's legal. And if it's not, it's going to cost you money in court to prove that it shouldn't bind you. So either way, we end up losing.
Right.
So the more preventative we can be in preparing and executing our contracts, the more money we save our clients in the long run, and the more headache we save them. Because at the end of the day, why are we writing these contracts? We're writing them for people to do business and make money. And if they're spending their money fixing problems rather than making money, then maybe we didn't do our job right. or maybe whoever the lawyer prepared the contract didn't do their job right. So take the extra minute, take the extra step, get a second pair of eyes, get a second opinion before you put ink to paper. And it will be a 10x return almost every single time, because even if at worst case scenario, that extra look or a second pair of eyes costs you a couple of dollars and it saves you litigation expenses in the future, you've already won. You're already ahead.
Mm-hmm.
And at best case scenario, you guys have ironed out terms that are so ironclad that in some cases, even going to court or litigating doesn't make sense. You're forced to settle the issue.
Are there any specific clauses that you see people routinely miss, routinely skip, not think about, that you would love to point out here today?
I think there are routine clauses that are in dispute. I think that's what really comes up, is the same issue more or less over and over. And most often it could be that what I got in exchange for what I gave you is not enough. The consideration is not there. Or it could be that your offer was not accepted. I didn't agree to what you said in this agreement. It's the ambiguity that creates the biggest threat of litigation on the other side. And that comes back to our point that skipping details and assuming that everything's going to be okay, that's what gets us in trouble. Not planning, not practicing preventative law. And that's what we end up seeing on the other side, is either it was done maybe not the best way, or unfortunately it wasn't done by someone who understood contract law well. And now we're in a position where people have to have an arbiter or a judge or a jury decide who's right and who's wrong, because it just wasn't written right.
Mm-hmm.
And that is our responsibility as professionals. I can understand if you're doing this on your own and you're doing your best and you're pulling forms online, which I wholeheartedly advise against with all of our clients.
Yeah.
But in a situation where you had somebody prep an agreement, you paid them to do it, and it still falls apart on the other side, you have to be careful and make sure that the professionals that you're dealing with practice what you're coming for help for.
Mm-hmm.
And back to our point, that's the most common reason for dispute is ambiguity. Some part of this agreement wasn't clear enough to both sides, and now it opens the door for one side to attack the other. And we want to avoid that at all costs.
Yeah, that's the whole point, right?
Absolutely.
Yeah. For businesses that are scaling, how often should they relook at contracts? Should they review contracts? Should they go over them to see if there's any updates that need to be, as a general rule, in your opinion?
I think as a general rule, at least on an annual basis. Look, if we're going through our financials annually, if we're filing our taxes annually, you're renewing leases, you're renewing equipment, you're buying new inventory, you're dealing with your vendors at least once a year, whether you're restocking or you're reservicing or you're renewing. So you should be reviewing and updating your agreements no less than once a year.
Okay.
Otherwise, we're falling into the same habit. What happens is, in most of these contracts, there's an automatic renewal. And sometimes that's not necessarily the best thing for both sides. The one that's putting in those provisions are putting them in with conditions. And it could be an increase. You're paying 10% more or 15% more, or now it's changing the scope of the contract itself on automatic renewal. And that renewal usually takes place at expiration. Most agreements, again, unless we're getting into, lengthy leases or we're getting into long-term deals, they're usually year to year. So I would say annually, as a rule of thumb, review all of your agreements, if not for anything else but peace of mind.
Yeah, I think that's good advice. It seems like one of those things that makes sense to people in theory, but the practice is the part that people slack on a lot of times, I would imagine.
I mean, look, the way that I see it is we're doing our taxes once a year. We're checking our finances once a year. You're updating your 401ks if you're able to. You're checking your savings, your bank accounts.
I go to the dermatologist once a year. We can do contracts once a year.
Exactly. So if you're already doing it, you're doing the work, you're going through all your financials, just take an extra hour, go through your agreements, sit with your lawyer, call Morgan Legal Group. We'll be happy to review your agreements for you. If not for anything else, to make sure that they're kosher, to make sure that there's nothing that needs to be updated or amended. And if necessary, we make the change. Mm-hmm. And look, changing agreements doesn't have to be a scary process. A lot of the times it really is. It's a bit of negotiation, a little bit of back and forth with the other side. It doesn't have to be a big contentious argument every time something needs to be changed. It just needs to be equitable. It needs to be fair. And as long as it's fair to both sides, we can avoid a lot of the drama and a lot of the costs that come with it.
There's the term bulletproof, for a business relationship or for a contract. Is that attainable?
It's definitely an aspirational term. Everything we do, we aim to be bulletproof. Mm-hmm. But the only thing I can really guarantee you is death and taxes, right? I can't guarantee that the day that the sun's going to come up tomorrow. Mm-hmm. But we strive for bulletproof. And I think that in a perfect world, we want our agreements to be bulletproof. But by the same token, a clever lawyer will find a way. And a lot of this comes from experience. A lot of this comes from knowledge of years and years of understanding what do the prior cases say, not just what do the books write, what do they teach you in school, but what have they ruled on? There's so much gray area that goes in to contract building and contract litigation. The closest you can get to bulletproof is making sure that it's as crystal clear as possible, that there is as little room for interpretation as you can put in place, mm-hmm. as little ambiguity as we can manage in an agreement. And in some cases, we have to go an extra step because people want to do what they want to do. So we have situations where we'll tell our clients that, look, this may not be the best fit for you. You may want to go in a different direction. Let's put this in place, or let's negotiate a bit more, because we're seeing the problems. We're seeing what could possibly go south. Mm-hmm. And sometimes people just need to roll the dice. And in some businesses, timing is more important. Opportunity is more important, but we still have to protect you. So in those situations, your job as a professional is to explain to your client that this is what we could have done. And if you decide to do something other than this, this is something that you're choosing to do either because you want to do it or because you have to do it, because it's opportunity, it's business, and it comes with risk inherently.
Sure. Yeah, makes sense to me. All right. Well, thank you very much, Russell. Make sure for everybody listening and watching, make sure your agreements protect your future. Visit morganlegalny.com. Call 888-529-1315. You can always check them out on social media too, @MorganLegalNY. Be sure to subscribe to our channel, listen to Obsessed with Success, and leave us a review. We really appreciate it. Russell, great stuff. Really enjoyed the conversation. Thanks for your time.
You too, Kevin. See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.